As part of the ongoing legal dispute about using the 1798 Alien Enemies Act to expedite deportations of MS-13 and Tren de Aragua gang members, a few weeks ago, D.C. District Court Judge James Boasberg of Turn Those Planes Full of Illegals Around Right Now fame issued a ruling saying there was probable cause to find Trump officials in criminal contempt for their non-compliance with his orders. And later, District Court Judge Paula Zinnes in Maryland said nearly the same thing in the Kilmar Abrego Garcia Maryland father deported to El Salvador case. Hey, the Supreme Court said you guys have to facilitate, and I'm not seeing much facilitation, so facilitate harder, or I'll hold you in contempt of court. And on first glance, I figure these threats deserve nothing more than a proper Fetterman response.
Ooh, don't do it. Please don't do it. Oh no, oh no.
And they do. You can't prosecute a sitting president, of course, and even though you can prosecute his staff, who's going to do it? You're going to issue a criminal referral to the Justice Department to prosecute the Justice Department or some sister agency? It's not going to happen. So the Fetterman response is properly earned on the first, second, third, and all the remaining glances too. But the point is, I figured there's got to be another angle here. These judges know that the usual method of prosecution is not in play here. And yeah, they are showmen on the biggest stage outside of Broadway now, but are they really making these threats just for show, or do they actually think they have a legal angle here? Dig a little deeper, and yeah, that is exactly what they think. And ironically, it's an angle that's very possibly illegal itself, unconstitutional, overstepping the boundaries between the branches that establish the executive as prosecutor and the judiciary as judge. If they actually try it, it's something the Supreme Court would almost certainly evaluate, but it turns out this has been done before, and in one case, not very long ago, actually. And in that case, the Supreme Court declined the opportunity to review it. If you read Judge Boasberg's ruling from April 16th saying probable cause exists to bring contempt charges, he says if the non-compliance continues, he'll refer the matter to the Justice Department. Oh no, not that, anything but that. But then there's Plan B. If the DOJ declines to pursue the charges, and they would, then the court, as in Judge Boasberg himself, will appoint another attorney to prosecute the contempt case. Well, since when do judges appoint prosecutors? Judges evaluate and oversee prosecution, sure, but they don't prosecute themselves. Well, since the adoption of the federal rules of criminal procedure, which is what Judge Boasberg is referencing. At Congress's direction in the 1940s, the Supreme Court was authorized to establish these federal rules of criminal procedure to standardize how criminal cases are handled across the federal court system. These rules took effect in 1946, and among these rules is what Judge Boasberg is citing. Rule 42. In cases of contempt of court, if the government, as in the Justice Department, declines to bring charges, well, then the court will appoint a prosecutor. On a surface level, that might make some sense. If the executive branch is defying the courts to a criminal extent, how can we rely on the executive branch to prosecute itself? There's a conflict of interest there. But on a constitutional level, on what basis does this attempt to address that conflict exist? The power to prosecute or execute the laws lies with the executive and no other branch. Just because there may be a conflict doesn't undo or invalidate that constitutionally assigned power. And these conflicts exist in all the branches. Congress sets the particular rules of lawmaking, even though there's a conflict of interest in that they're writing the rules that govern themselves. Even in this case, the courts set the particular rules of adjudication, even though there's a conflict of interest in that they wrote the rules that govern themselves. And there are multiple constitutional accountability mechanisms for the president anyway. If the people don't like how the president prosecutes, or doesn't prosecute in this case, well, then they can impeach him through Congress, or they can vote him or his party out of office in the next election. Now, as a practical matter, we haven't had many opportunities to evaluate where this supposed constitutional authority for a court to appoint a prosecutor actually comes from, because Court-appointed prosecutors for contempt cases don't happen very often, but when they do, the Supreme Court has either upheld it with limitations or just looked away. In 1987, a guy named Young was prosecuted for contempt by a district court-appointed private attorney. He challenged to the Supreme Court, arguing the courts have no constitutional authority to appoint a prosecutor. The Supreme Court, in a 5-4 decision, upheld the appointment power under the reasoning that the courts need their own enforcement mechanism for defying them, and that the courts should not be at the mercy of the executive for that function. However, the Supreme Court reasoned that these private prosecutor appointments should be restrained by the principle that the case should be referred to the Justice Department first, and the appointment should only happen if the DOJ declines to bring the charges. So later, the language of Rule 42 was updated to reflect that process. Go to the DOJ first, then the district court judge can appoint a prosecutor if he's denied. A strange decision in that it tries to reconcile incompatible points. It grants executive branch authority, but then undermines it. Go to the DOJ first. Why? Because they have constitutional authority in the matter? Well, unless they say no, because then they don't have that much constitutional authority in the matter, and the courts get the final say. Dubious reasoning, if you ask me. You don't actually have authority if your authority depends on how you exercise it. That means someone else is actually in charge, but them's the rules, according to the Supreme Court, since 1987. A court-appointed contempt prosecution happened again more recently in the case of Stephen Donziger, an activist environmental lawyer known for fights with Chevron, the oil company. He won $9.5 billion from Chevron for supposedly causing health problems and environmental damage in Ecuador. Chevron responded with a racketeering lawsuit against him. A judge determined that Ecuador case was improperly or corruptly handled, and Donziger was disbarred in New York. In that case, Donziger refused to surrender his electronic devices. Ultimately, the court appointed a prosecutor for contempt charges in this case too, and Donziger was convicted in 2021. Donziger also appealed to the Supreme Court, but the Supreme Court declined to hear his case in 2023. So his conviction stands, but Donziger had already gone to prison and been released anyhow. Donziger's legal argument is that the court appointment of a contempt prosecutor violates the Appointments Clause of the Constitution. This clause in Article 2 says Congress creates offices and the president makes appointments to fill them. There is nothing in there about judges creating offices and then appointing people to those offices themselves. In declining to hear Donziger's case, the 7-2 Supreme Court majority offered no commentary or reasoning, but in dissent, Neil Gorsuch did, and he was joined by Brett Kavanaugh. And Gorsuch ripped Rule 42 and this concept of court-appointed contempt prosecutors apart. Just broadly, it violates the principle of the separation of powers and the constitutional roles of the branches. As the Supreme Court itself has recognized, courts are supposed to be neutral adjudicators, not prosecutors themselves. Do we let prosecutors judge guilt or assign sentences? No, because that's not their role, and likewise, prosecuting isn't a judge's role either. But on the specifics, this rule fails too. There's a technical argument that actually Congress gave the courts the power to make this prosecutor appointing rule when they directed the Supreme Court to establish uniform rules for the court system. Yeah, that's neat, but Congress saying, hey, Supreme Court, could you please make some rules in defiance of the Constitution, doesn't actually undo the Constitution. If Congress directs the Supreme Court to do away with due process, that's not legally square either. And this isn't an act of Congress anyway. Congress said nothing about creating this rule in particular. They didn't say, hey, could you please create some rules about appointing your own prosecutors? And this rule defies most everything the Supreme Court has said about appointments otherwise anyway. In several cases, including U.S. v. Nixon, the court has recognized that the executive branch has exclusive authority and absolute discretion to decide whether to prosecute a case. Except in this one case, which of course makes the authority not exclusive and the discretion not absolute. In the 2021 case of U.S. v. Arthrex involving the appointment of patent judges at the Patent and Trademark Office, the Supreme Court held any principal officer has to be appointed according to the Appointments Clause, office created by Congress and filled by the president. What makes a principal officer? Someone with binding decision-making authority not reviewable by some superior. Well, criminally prosecuting someone is certainly a binding decision, and who oversees these court-appointed contempt prosecutors? Nobody. They're not part of the Justice Department. The president doesn't pick them. They're picked by a judge who then passes them off to another judge to handle the case, which is itself an acknowledgement of the inherent conflict of interest. And in several other cases, the Supreme Court has said the exact same thing too. No Consumer Financial Protection Bureau. You can't have your own independent director removable only for cause. That person has to follow the Appointments Clause rules. No SEC, you can't have your own administrative law judges who aren't accountable to Congress or the president. They have to follow the Appointments Clause rules too. So will the Supreme Court review the issue again? Last time they opted not to, but a case that more directly imposes on presidential power and tries to prosecute executive branch officials may force their hands. But of course, while we're talking constitutional power, all of these technicals may be moot anyway. Because what happens if Judge Boasberg actually does appoint a prosecutor? And that prosecutor actually does bring charges against Kristi Noem or Tom Homan or some other immigration official, and that prosecutor actually does secure a conviction. Are they actually going to prison? Will Trump say, okay, fine, Judge Boasberg, you got me. I'm taking my plane down to El Salvador to pick up a bunch of Tren de Aragua guys and bring them back to Mar-a-Lago to give them the party they deserve? No, of course not. He's going to say, wow, cool charges, bro. Cool trial, bro. Cool convictions, bro. But they're pardoned. And maybe you say, yeah, but does he really want the corrupt appearance of pardoning his own people? Yes, what a strange new day in America that would be. How would the country ever recover? How would the country ever continue if a president exercised his pardon power to protect his own? And at least in this case, there would actually be a specific charge to evaluate, unlike last time when it was just anything and everything that might have happened sometime in the last decade. And for whatever scrutiny of presidential corruption there may be, there's more scrutiny due to the judge who started this whole process to begin with, exceeding his constitutional role to become all three branches of government himself. Ironically, with no accountability mechanism against him, not even impeachment, which our Supreme Court Chief Justice says is not the appropriate remedy for such points of disagreement, despite plain constitutional language and historical founding-era example otherwise. So, practically speaking, I guess this is exactly the show that it seemed like it was in the first place. I did the technical tour to figure out exactly what they're threatening, and I almost forgot that the president has the final say in this matter regardless. And surely these district court judges must have the legal expertise to understand that, which means they are doing exactly the theatrics that it seemed like they were. Until we get to the next step in the judicial power grab. Well, sure, the president has the exclusive power to prosecute, but no, not like that. And sure, the president has the exclusive power to pardon, but no, not like that. And in the interest of honesty and transparency, yes, I myself have questioned the limits on presidential pardons with Joe Biden's open-ended, undefined, and preemptive pardons as they contradict the English common law tradition that is the basis for the power. But my point is, you can see where this is going, and I don't think it's just in pursuit of a Tony Award for Best Stage Performance. It's to keep pushing the premise that, yeah, sure, all branches of government are created equal, but one branch is created far more equal than the others. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X, that is at ML Christiansen. You're always welcome to coming out and chatting my live streams as live on Wednesday and Sunday nights. Looking forward to it. Goodbye. Hey, if you made it all the way to the end of the video, that means you probably found some value in the video. If you found some value in the video, please consider supporting my material. You can do that one time or recurring for as little as $1 a month. It not only helps me sustain, but it helps me pay the people who make my videos possible. Linked in the description for you, mattchristiansenmedia.com/support. Thanks for listening.